your case that, for example, you had seen a physician regarding this matter that you did not disclose on the form, then that could hurt your case. And it could, in fact, mean that the compensation that you receive down the road could be less than what you are entitled to. Now, when you're filing a claim of this nature, it is important that you understand that your injury must be permanent. If, for example, you break your arm on the job, the employer is responsible for paying to have your medical expenses and other matters involving this taken care of, your transportation, what have you. But if your arm heals and you're fine after this, you don't have a permanent injury. If, on the other hand, you were to lose that arm, you would have what is known as a permanent injury, and this would be recoverable under the terms of the Act. In order to file the claim, you also need to file a medical report from your physician with the claim forms. There's a specific form provided by the Workers' Compensation Board which can be used, or just a standard medical report that your physician would issue in the form of a letter will suffice to do this. But it is important to have a medical opinion which substantiates your claim. It is not good enough for the employee to say, well, I hurt myself and I'm 100% disabled, I can't go back to work. You need to have a physician who will give an opinion to that effect. Once you have filed your claim, the Workers' Compensation Board will issue an order which sets out the time period in which proof can be gathered in the matter. Each party, that is you and your employer, have a certain period of time in which they can take proof and make that part of the record before the board. After that time period expires, we have what is known as a pre-hearing conference. What this basically is a settlement conference where the employee and the employer and their representatives will meet and will discuss the possibility of settlement, and will try to narrow all of the issues that are involved in the case. If at that point in time a settlement cannot be reached, then it would be necessary to have a hearing where any witnesses who had not been, their statements had not been taken during the time periods set out before would be able to come and testify on behalf of the employer and on behalf of the employee. The administrative law judge, who is the person who will be trying the case, will make a decision at the hearing as to the level of compensation which will be awarded and will set out the amount to be paid on a weekly basis by the employer or his insurance carrier. The attorneys involved on behalf of you as a claimant will be paid from whatever sum that they can recover on your behalf before the board, either at the settlement or at the hearing level. There are certain statutory provisions which set out the amount of recovery, but basically we're talking about 20% of the first $25,000, and then there'll be a lesser percentage for amounts recovered above that. There is no fee paid until the administrative law judge makes a determination that the fee is reasonable, and he has to approve any fee that's going to be paid. There are certain options which can be followed in paying that fee, and those would be explained to you by your attorney. It's important to stress that, once again, that you consult an attorney very early on in this process so that you can make a determination as to what evidence you'll need to gather in order to effectively present your claim. The more evidence that your attorney can gather, the earlier that an attorney can get involved in this process, the easier it's going to be to settle your claim and to move your claim along. The quicker that this gets started, the quicker that you'll receive some kind of compensation.
If you have any other questions about the Kentucky Workers' Compensation Law and your rights as an injured employee, contact an attorney of your choice. Most attorneys do not charge for the initial consultation. Thank you.